Very warm welcome to this Export Insights webinar hosted by Herrington Carmichael Solicitors, Saffery Chartered Accountants and Business Advisors, and MJ Trade Advisory, Export and Sanctions Compliance Consultancy. I'm Mark Chapman, partner at Herrington Carmichael Solicitors, specialising in commercial and regulatory matters. My co-presenters today are Nick Hart, partner and VAT specialist at Saffery, and John Whitworth, principal consultant at MJ Trade Advisory, Export and Compliance Consultancy. So over the next 1.5 hours, we're going to cover some of the key export related topics from legal, VAT and sanctions and export compliance perspectives. Because we've only got an hour and a half, it will be a fairly high level run through of some of the key points, but hopefully you'll find it useful. So a couple of housekeeping points before we start. The webinar is being recorded and a copy of the webinar and slides will be provided after the event. There will be the opportunity to ask questions and participate in the discussion if you'd like. Probably best if questions are kept to the end, because it's possible we might cover things as the slides progress. But if you do have a question you'd like to ask, then please put the question in the chat. One of the points to note there is that the question will be visible to everybody. So if you have a question you'd prefer to keep private, then please ask one of us after and we'll be pleased to help. Alternatively, if you do have a burning question you'd like to ask, then please raise your hand and we'll do our best to answer the question at that point. If it's something we can't answer, then we'll take it offline and help afterwards. Like I said, we are hoping to have time to answer questions at the end, but if not, we will follow up with people after the event. So hopefully that covers the housekeeping points. So without further ado, we'll make a start. So quick intro about Herrington Carmichael Solicitors. We are a full service law firm with our head office in Farnborough in Hampshire. We've got over 200 staff providing the full range of legal services to individuals and businesses. I sit in the commercial and regulatory team, so we help clients with a full range of contract and regulatory matters, including in relation to sanctions. More broadly, the firm assists clients with corporate matters, for example, mergers and acquisitions, banking and refinancing, and also in relation to disputes, intellectual property rights, employment and property matters. So we cover the full range of legal services. We help clients with a lot of international projects, and the way that we do that, where local law advice is required, is we manage those projects on behalf of clients using members of our international network, IR Global. We've got a lot of experience doing that, both in private practice and in-house. So if there's an international project that a client needs help with, we're well placed to assist with those. Just a quick background about myself before I start talking. So I trained at Herrington Carmichael and then worked in the in-house legal teams in industry before rejoining Herrington Carmichael about 13 years ago. So some of those in-house positions in particular involved managing international projects for large corporates. So a genuine pedigree there in that sense. So just a quick point before we get into the presentation, which this point is applicable to everybody, just to really reinforce the fact that we're going to be covering things at a high level here. The types of topics we're touching on today are really quite fact sensitive in relation to what should and shouldn't be done in a particular context. So it's general information we're providing here, which isn't a substitute for proper advice in relation to any specific queries you may have. So always seek advice of a professional before you take or refrain from taking any action. So in terms of the discussion today, we're going to start off with some legal points, and then we're going to hear from Nick on some VAT related points before coming back to some contract related points, and then hearing from John in relation to export and sanctions and compliance. So when clients come to us and we have the first conversation around exports, the first question or the first conversation we're really having is around what is the route to market. And from a legal perspective, there are three key routes to market here. I've popped them up on the slide there. So the first one is direct sales. Alternatively, there's distribution or agency. So there are three main categories. There are pros and cons to all of them, and I'll take you through a few of those each now. And depending on which model you choose will depend on how many of the things we're going to talk about in subsequent slides will be relevant to you as a business, and what you have to do in each of those scenarios. So it can vary, but the core principles of the things you need to think about will remain broadly similar. So direct sales, the first one that we've listed there, is where a business will sell directly into a new market, either through existing entities or perhaps setting up a new subsidiary to manage that new territory on its behalf. It's can be an attractive option to a business, but it can often involve the most preparation up front, because the business should take steps to understand the local market and the requirements of operating in that market. For that reason, distribution can be attractive if it's a new market that a business is entering into, because with the right due diligence and selecting the right distributor, then that distributor should have the knowledge of the local market. So the business is selling to the distributor, who's then making onward sales into that local market. So it can be a good way for a business to find their way around a new market. Agency is another option, which is where a business appoints an agent to act on its behalf and conclude contracts in its own name. So again, if you choose the right agent, then they'll have a knowledge of the local market. With all of these things I mentioned at the start, there's pros and cons. So there would very much be, tax and accounting advice that would be needed to help select the most appropriate route to market, which is then combined with the legal advice on the various pros and cons and risks of operating in those jurisdictions through those various different models. Due diligence is really important from a legal perspective when expanding into a new market or territory, because there can be aspects which are quite different to operating in the UK. So, for example, in some jurisdictions, distributors are entitled to compensation when their distribution agreements are ended, which is not the case in the UK. That's much more similar to an agency model, where an agent is protected by the commercial agents regs if they fall within that regime. So it's really important to do that analysis to understand what you're getting into as a business before you start. So in terms of legal things to be aware of, and one of the main things is around the contractual arrangements between the various parties. They will vary slightly in terms of the content and the form of the contracts, but lots of the provisions will be the same, irrespective of which option the business chooses to go down. So we've listed out a few things over the next couple of slides, which I'm going to talk you through now, just to give you a flavour of the key things to be aware of. So the first one I've listed there is around governing law and jurisdiction, local laws and local council advice. So if I break that down, in relation to governing law and jurisdiction, it's really quite important when a client comes to us with a contract to review, the first thing we're doing is to have a look at what the governing law and the jurisdiction is. So there's two components to that. What is the governing law of the contract, and where will any disputes be held? That's the jurisdiction part of it. The reason that's so important is because it informs how the contract's going to be interpreted, at least in part. So we are able to advise on the laws of England and Wales. If a contract is outside of those jurisdictions, then we can assist with the local law advice that might be needed or desired in relation to it. An important point to make, which is often a common misconception, is that if you had an English law contract operating in another jurisdiction, then we know exactly what the makeup of that contract is. And that's not quite right, because you can find situations where there's mandatory local laws which will override provisions in the contract, or which will be implied into it in addition. So if a business is using an English law contract in another jurisdiction, it's always our recommendation that we take local council advice. And what we're doing when we go out to local council there is really wanting to understand those 2 points I mentioned. Are there any mandatory local laws that will be relevant to this contract? And is there anything that will change what's written down on the paper, or how it would be interpreted? And that's where that local law advice is really invaluable to take up front, because then we know what we're getting into as a business. The jurisdiction piece is important because it's stating where any disputes in relation to the contract would be heard. And whilst courts of one jurisdiction can typically apply the laws of another jurisdiction, it can make things more complicated, and it can also make enforcement more costly if it's outside of your own jurisdiction. So have a look at that and look at it carefully, because that's quite important. I mentioned local laws and local counsel advice there. It's really fundamental to kind of do that due diligence up front, and it's a common theme that's going to run through these slides as we work through the presentation. Due diligence and knowing what you're getting into, but not just at the start, on an ongoing basis as well. So that's the governing law and jurisdiction piece in a nutshell. Limitations of liability will be important because as a business, you will be selling into jurisdictions that you may or may not be that familiar with. And therefore, it's really important to pay attention to your potential exposure under the contract from a legal perspective. So more than ever, you're going to want to be having appropriate limitation of liability provisions in the contract to the extent that you can. There's some things that it won't be possible to limit or exclude liability for, but a key point to look at in those contracts. Insurance is a really important thing for businesses starting to trade with overseas counterparties to think about. I'll come on to that in a bit more detail a bit later, but you want to check with your broker whether your current insurances will cover that trading activity, for example. Very simple things, but make sure they're not overlooked when you're starting to export into those new territories and jurisdictions. Licenses and authorizations. This would be part of the due diligence to understand, do you need any specific licenses, authorizations, or permits to sell your products into these new territories, depending on which route to market you go down. But it may be that a product requires a specific permit or license to be sold in a jurisdiction, in which case you want to make sure that that's in place, or there are arrangements for it to be put in place by somebody in the contractual chain such that it's sold on a compliant basis. Final point on this slide, before we move on, is sometimes, very occasionally, we see contracts which refer to the convention on contracts for the international sale of goods. And what this aims to do is introduce uniformity for contracts. It was adopted by the UN in 1980 and came into force in 1988, but the UK hasn't ratified this code. It can still be applied by the parties by election, but doesn't override mandatory local laws. It can be used in conjunction with Incoterms, but it doesn't have to be. And the point I would make around it is it's meant to make contracting more straightforward, but in all the time I've been practicing, it's only been applied, a small number of times in contracts, principally because the UK has not ratified it, albeit it can be applied by election. So something to look out for, but doesn't come up very often, but it can come up in the context of governing law and jurisdiction. In relation to contracts, then a few more points to be aware of in relation to exports and moving into new markets. So when trading overseas, considerations around payments, securities, and currency fluctuations can become much more relevant. So if I take each of those in turn, when you're moving into a new market, of course, you want to make sure you're going to get paid. So what payment terms are you going to have? Are you going to require payments up front? If that's not possible, are you going to try and take some security in order to increase the chances of getting paid for the goods that you've supplied? The security can take many different forms. You could have guarantees from parent companies or from individuals. You could have bank bonds and similar in relation to securing payments and giving you more comfort in respect to those, but of course they all come at a cost. So there's a commercial analysis that needs to be undertaken as to which is the most appropriate route for you to go down, and really keep on top of that credit control and the credit limits that you apply. I've listed something on the slide there, the Export Credits Guarantee Department, which is a government-run initiative, and it is possible to get some guarantees or insurance for overseas trade, and you can get quotes in many cases instantly online via the website. So it's well worth looking into if you're moving into a new market, because it can help provide some assurance against non-payments and defaults in payments. Of course, when moving into a new territory or selling overseas, then currency becomes relevant, and clauses around which currencies are going to be used for the contract and who bears the risk of currency fluctuations can be very relevant. I've mentioned brand protection. If you've got intellectual property rights and a brand that you want to protect, which has got some goodwill associated with it, for example, then you need to think when you're moving into the new markets, do you need to extend the current protections you've got, or is what you have already sufficient? So there will be questions around things like trademarks. There will be questions potentially around patents and about any registered designs, etc., that you've got. But it's worth thinking about these things before you plunge too far into that new market, just to make sure you've got in place what you should have in terms of protections. I touched on disputes briefly a minute ago, but of course, if you're trying to enforce contracts with counterparties based overseas, then that enforcement becomes more complex, because you've got a geographical dimension to it, as well as, you know, overseas legal requirements. So you need to go into those kind of arrangements with your eyes open, because it's not to say you shouldn't do it, but again, that due diligence becomes key. And it's really about how do you avoid disputes in the first place. And two key things around that would be having very clear, robust contracts in place, and doing your due diligence. And thirdly, around payments, really making sure that you've got the requisite security to make sure that you increase the chance of getting paid when you should. Penultimate point on that slide then around Incoterms. So Incoterms can be very relevant in terms of international sales of goods, and they can be incorporated into English law contracts, and they fairly frequently are. But what I would say on those, again, is that due diligence and understanding that's really key, because all too often clients are coming to us talking about Incoterms, but when we get into and explain the Incoterms to them, it doesn't match with their understanding that they had before they came into the conversation with us. So it is important to understand what you're signing up to, and there's some really good diagrams on the internet to show where the different risk areas in relation to Incoterms sit and what they cover. But I think two key points for me to make on Incoterms, apart from making sure you understand what they cover, is when you're selecting them, it will really depend on which side of the fence you're sitting on, buyer or seller, depending on which one you would want to choose, because the Incoterm chosen will dictate for that contract who has to do what in the contractual process, including being responsible for loading and unloading, clearing things through customs, paying duties, and also in relation to where risk passes. So it's really important to get an understanding to make sure you select the right one. Another point to make on Incoterms really is around that they don't deal with everything. They deal with some of the more mechanical and operational pieces of the contract, but for example, they don't deal with title, so ownership of the goods. So the Incoterms are not the full contract, they're part of a wider contract, and they're often built in by reference. So it's important to just note that they don't cover everything. There's also other bits that you'll need to make sure are covered. The final point on Incoterms that I'll make is that not all Incoterms options are suitable for all methods of delivery. So for example, free on board is only suitable for sea freight, is not suitable for other forms of freight. So you need to make sure that it's matching up with how you're actually going to operate the contract in practice. And the final point on this slide is around the fact that there are VAT and accounting considerations which need to be taken into account when beginning to export or trade overseas. And with that, I'll hand over to Nick for some thoughts in relation to VAT.
Thank you, Mark, very much. Good morning, everyone. A pleasure to be co-presenting on this webinar this morning. Just a brief intro to myself and Saffery. So I'm Nick Hart, VAT partner at Saffery. Saffery was established in 1855, so we're a firm with a very rich heritage. We're a top 20 accountancy, audit, tax practice, providing the range of services that you would expect from such a firm, and myself as a VAT specialist advising a whole myriad of different types of clients on all of their VAT matters, but in particular matters relating to international trade, import, export, etc. is quite a large proportion of what I do and what I advise our clients on. So just moving on to the next slide. So what am I going to be talking about for this next section? So I'm going to focus on, not unsurprisingly, VAT and the zero rate that is available to apply to supplies of exported goods. Just to clarify, an export of goods from the UK is a shipment of goods to an overseas jurisdiction. What we're not talking about when we talk about exports is anything being shipped from Northern Ireland to the EU. So under the Windsor framework, Northern Ireland is still part of the EU from a movement of goods perspective. So it's still in the EU VAT system with respect to intra-EU shipment. So if you do ship anything from Northern Ireland to the EU, the export points are not particularly relevant, and it's more intra-community supplies of goods, and the conditions are slightly different for those types of scenario. But so just focusing on exports for this presentation, I'm going to be taking you through the zero rate for VAT, when that relief applies, and what conditions need to be met in order for it to apply. So there's some time limit conditions and evidence conditions. A couple of points on this intro slide. Zero rated supplies, zero rated outputs, they're still reportable on your VAT return. So they would go in, even though you're not charging VAT, you would still report the value of those supplies in box 6 of your VAT return. So they need to be coded in the appropriate way through the accounting software to ensure that that is the case. If you are a relatively new business and you're not currently VAT registered, then your export supplies do count towards your taxable turnover. So that's currently 90k for VAT purposes. So your export supplies, again, even though you're not charging 20% VAT, they would qualify towards that VAT registration threshold. In some instances, we see businesses that only make export supplies may not be VAT registered at all. That's probably slightly more unusual because by not being VAT registered, you would lose out on VAT recovery opportunities. So we typically see businesses with a high proportion of zero-rated export sales. Yes, they're VAT registered, and often they're on monthly VAT returns because they are in VAT repayment positions, typically. So moving on, we're going to just the two types of export that are eligible to be zero rated. So these are specifically VAT terms. So direct export and indirect export. So direct export first. These are VAT terms. They appear they are covered by VAT legislation. So they are very much for VAT purposes only. So a direct export occurs when a UK supplier sends goods to a destination outside the UK and is responsible for arranging the transport, either through its own resource and fleet of vehicles, etc., or more commonly through freight forwarders, shipping agents, freight agents, etc. We would typically see for direct exports the UK suppliers EORI number on the export declaration. So for those of you not familiar with what an EORI number is, it stands for Economic Operator Registration Identification, bit of a mouthful. But it's a registration, and it's a number that identifies the exporter in this case, or similarly for imports, the importer, through the customs process. So it's a necessary thing if you are exporting goods and you are the exporter of record. You need an EORI number to be able to be appropriately identified through the customs process. Indirect exports, this is where your customer will be picking the goods up from you in the UK. So an overseas customer, that is. Be specific on that point. What is an overseas customer? An overseas customer is a business that is not established in the UK, so has no presence in the UK in terms of physical presence or employees or etc. So an overseas customer collects the goods from the UK supplier and the overseas customer arranges the transport themselves and the export themselves. So that's an indirect export. In terms of Incoterms, which Mark touched upon earlier, this would arise on ex-works Incoterms, which is at the far end of the Incoterms table, so to speak, where the buyer of the goods is basically on the hook for all of the kind of risk, insurance, costs, and the export declaration in the country of export. So I'll talk a little bit more about the additional risks that indirect exports pose for UK suppliers in seeking to apply the 0% VAT relief in a short while. Yeah, just the bottom point, in some circumstances, the overseas customer may have a UK VAT registration as a non-resident trader. They can still qualify, this can still qualify as an indirect export, provided they are not established in the UK. So on the basis they have no presence here, they will still be qualified as an overseas customer, and it can still be an indirect export. So we've got indirect exports, direct exports. Those are the two types of exports, as I said, as defined in VAT legislation, that are eligible for the zero rate of VAT to be applied to. What are the conditions? So there are two main conditions. There's a time limits condition. So the goods must have been exported from the UK within a specified time limit from when they were actually supplied. And also the other condition is around evidence that the goods have been supplied, so that there has actually been a transaction, a sale of the goods, and evidence that those goods have been exported within the specific time limits. Now, on the conditions and just around the application of the zero rate VAT relief in general, this is something that HMRC look at whenever they're checking the records of a business that is supplying export goods. So it's very much on their radar. It's kind of a default for assurance officers when they're looking at a business that has export sales to want to look at that these conditions have been met. So they'll be asking for the export evidence. They'll be asking for evidence that the time limit conditions have been met, etc. It's very much something that they will look at, almost guaranteed, once they understand that you've got export sales within your business. So if we move on to what those time limits are, actually there's some, just before we do that, some additional conditions for indirect exports. So those are the ones under ex-works Incoterms, where the overseas customer is picking up the goods in the UK. Goods must not be used between removal from the UK premises and the export. And there's some points there around the zero rate cannot apply to supplies to an overseas visitor exporting in company baggage, a private UK resident individual, or a customer with a UK business establishment making taxable supplies. That goes to the definition of what an overseas customer is. There are some circumstances where goods in an indirect export situation may be sent to a UK party before export. You might find that that's for consolidation with other goods for the shipment, or to an extent, a certain processing of those goods before they are exported. Have to be careful in those circumstances that that level of processing doesn't mean that the goods have been used, because otherwise we start to fail the conditions for applying the zero rate for indirect exports. And so it's really important that as a UK supplier seeking to apply the 0% in these circumstances, that you fully understand if goods are being sent to a UK party before export by the overseas customer, what the reason for that is, and what evidence can they provide to substantiate that, because it might mean that ultimately the zero rate can't be applied in those circumstances. So the time limits. So getting through the conditions in a little bit more detail. Time limit for direct and indirect exports, 3 months from the time the goods are supplied. So yeah, you basically have 3 months for the goods to physically leave the UK having been sold. Time limit for obtaining export evidence for direct and indirect exports is also 3 months. Time limits are extended to 6 months in the case of supplies of goods involved in processing or incorporation prior to export, so a little bit longer in those circumstances where the goods are subject to eligible processing prior to being shipped out of the UK. If these time limits aren't met, then the standard rate of VAT applies to the supply, and so VAT becomes chargeable at 20%. If subsequently, in the case of export evidence, if you don't meet that 3-month condition, but you subsequently meet it, then you can still be eligible to apply the VAT relief and apply 0% later on, at the time where that evidence is collected and available. But if you fail the 3-month condition, then you apply 20% VAT, but that can be amended, as I said, in the case the evidence is available later on after that 3 months. But HMRC would assess if you'd failed the 3-month and then you were still attempting to collect export evidence from various parties, they would assess and 20% VAT until such time as you were able to satisfy that condition. Export evidence. So export evidence is one of the conditions to apply the zero rate. It comprises, in practice, it comprises a bundle of different things. HMRC's expectation here is that it's not a single document that ticks the box here. It is a bundle of non-contradictory evidence and documentation that supports the fact that a supply has been made, so goods have actually been supplied, and that those goods that they qualify either as a direct export or an indirect export, and that they have physically been exported from the UK. So, as I said, there isn't a single document that is going to satisfy the condition in terms of export evidence. It's very much a bundle of documents, a bundle of evidence that the UK supplier needs to hold to substantiate applying 0% VAT. 3 categories. We've skipped on a little bit. If we could go back to the next one. There we go. Thanks. 3 categories: official evidence or commercial transport evidence, plus supplementary evidence and evidence a supply has taken place. So this bundle of evidence that I've mentioned, it's either going to comprise official evidence with supplementary evidence or commercial evidence with supplementary evidence. And we'll go into a little bit more detail about what those things actually are. As I said, HMRC will check this as part of VAT assurance events. It's a matter that often ends up at tribunal in cases where the UK supplier believes that they hold sufficient evidence to demonstrate the goods have been exported, etc., and therefore can apply the 0% VAT. And HMRC disagree, and they feel that sufficient evidence isn't held, and that kind of dispute can often end up at tribunal. So we regularly see first tier tax tribunal cases concerning the validity and the appropriateness of export evidence as the key matter. So it is certainly, as I said, it's certainly something HMRC are very mindful of, and will be checking on assurance events and are pretty hot on it. The other time it can become an issue is if you are an export business and you are the owners are exiting and selling the business, and through due diligence, if you are an export business, your export evidence and your controls and process around export evidence will be kind of tested and considered through the due diligence process. So it's something that can have an impact on on the sale of companies that have high proportions of export sales if it's not something that has been given the appropriate care and attention by the business. So again, it can become an issue in DDs in that respect when there's disposals going on. So a little bit more about what those three different types of evidence comprise. Official evidence is the export declaration itself, with the guaranteed departure confirmation through the Customs Declaration Service. For goods exported under a transit regime, the discharge transit movement constitutes official evidence. So typically, the export declaration itself will qualify as official evidence. It shows the exporter, the exporter's EORI, etc. And obviously is the declaration of the goods being removed from the UK. Commercial evidence is more to do with shipping documents, however form that shipping takes, whether it's air, road, sea, etc. So waybills, consignment notes, bills of lading, certificates of shipment, etc. So the documents that shows, describes and demonstrates the physical movement of the goods from the point that they're loaded onto a vehicle to the point that they arrive at their ultimate destination. And then supplementary evidence is kind of the information that you would hold as a business or would be expected to hold where you've made a supply of goods. So customer orders, purchase orders, contracts of sale, the sales invoice itself, the commercial invoice that goes with the shipment, packing lists, advice notes, consignment notes, insurance, evidence of payment, etc. So there isn't going to be instances necessarily where you would hold every single bit of evidence that HMRC lists out in its export notice. Helpfully, VAT notice 703 does list out the export evidence that HMRC would expect to see within the bundle, but not all of that applies to each different type of supply. So it's a case of making sure your bundle comprises as much documentation as HMRC expect, but which is applicable to that type of transaction, because obviously there are different commercial circumstances where under which transactions take place, and obviously this also applies not only to B2B export sales, but also to sort of B2C sales, particularly e-commerce sales to overseas customers. There's still an export in those circumstances. The use of a fast parcel carrier for shipment purposes, you may there are specific documents that HMRC would expect to see, and you wouldn't necessarily have all of the things that are falling into the default supplementary evidence list in those circumstances. So it's very much a case of collecting and retaining that bundle of evidence as appropriate to that particular transaction or the commercial arrangements that are in place. I think it's worth pointing out at this stage that in my experience, business can place an over-reliance on third parties in terms of retaining export evidence. So typically businesses will outsource or will appoint freight agents to undertake the actual shipment of the goods, etc. And they are obviously handling, and to complete the export declaration, they are obviously handling all of that paperwork, etc. And the business doesn't necessarily have a direct line to that paperwork. So there's a risk of over-reliance where the third party, do they know what they need to retain for the business to be able to, for their client to be able to support their VAT position? Do they know what's expected in that respect? Do they know how long they should be retaining that information for VAT purposes? Business records, of which export evidence would form a part, need to be kept for 6 years. So is the export evidence being retained for that length of time? And is it in their contract? Do the terms with the agent, the freight forwarder, the transport company, does their contract require them to retain this information, or is there anything in there that puts obligations and terms onto them to transfer information across to make that information available? So it can be a real risk where the business thinks he's asked for export evidence and they sort of say, well, our agents take care of all that, it's all in hand, etc. And then we might have HMRC asking for copies of that evidence, and it takes a long time for it to be retrieved. In some cases, it can't be retrieved; it wasn't retained, which obviously lead to some issues. So there's a real care piece here and a real recommendation to not over rely on your third parties that you're using. In these cases, it's very much you as the supplier of the goods. You're the one that has the VAT risk. It's up to you. It's your obligation from a VAT perspective to ensure the right evidence is being retained, and you have, if you're not retaining it directly, that you have access to it and you have reasonable time frame to get that access. So it's very much a case of do review those arrangements, because we can often see issues arising where there is over reliance on third parties. A little bit more around indirect exports. You can imagine that and appreciate that in the case of an indirect export, the overseas customer is picking the goods up from your warehouse, and then is responsible for everything else in terms of the shipment of those goods. So as a supplier, you don't have any sort of control or direct line of sight to the shipping documents or the official export declaration, for example, and that can pose a high risk as well, for similar reasons that the UK supplier doesn't have direct control, and therefore there's a little bit more stringency around the export evidence with indirect exports. There's greater risk. HMRC know there's greater risk. They will expect a more granular level detail to prove that the goods left and the transport and the shipment actually took place. So we're looking at things like, I mean, this comes from the 703 notice that I mentioned, getting down to granular detail of the transport route, so the route the goods took, what evidence have you got to demonstrate that, the vehicle details of when the goods were picked up, and other vehicle details along the route as well, where there is a change. Travel tickets is an interesting one. So I think it references sort of the travel tickets of respect to getting a truck onto a ferry, and those sorts of things. So that's a real level of granular detail that do be prepared for, and do your utmost to fulfill when you are dealing with your overseas customers, whether it is ex-works Incoterms. That's not to say that you've ticked all the boxes, you've got a nice strong bundle of evidence, and you just don't have travel tickets. I think probably HMRC would accept that. I think they do apply balance of probabilities and balance of the information they're looking at. So, but just to warn you that there is a much more greater onus on indirect exports in terms of the UK supplier collecting and retaining all of the sufficient evidence to demonstrate the goods were exported. Just on that, and the last point from me around indirect exports in particular, because of the heightened risk for UK suppliers in applying 0% VAT, where the onus is on the supplier to collect the export evidence from the customer. We often work with clients and advise them to adopt commercial terms that require the customer to provide this evidence. So contractually, they need to provide X, Y, and Z, the export declaration, the shipping documents, etc. So contractually, they're obliged to. They are under the terms. They are obliged to provide that information within the 3 months to the UK supplier. Going one step further, we often recommend, particularly where the customer is a new customer, you don't necessarily have the long-standing commercial relationship with that party. You haven't built up that sort of trust, if you like, is that you charge 20% VAT until your customer does provide the export evidence to your satisfaction, and then you credit them that and reverse the position and apply 0%. And again, adopting that position, it's recommended that gets included in the commercial terms, so both parties are on the same page in that respect. So it just provides a little bit of an insurance policy to the UK supplier, protecting its VAT position, protecting its risk, collect 20% VAT from the customer on the understanding that once they stump up the required export documentation, etc., that you'll reverse the position and credit that VAT back and effectively apply 0%. So that concludes my section. There's my contact details there, should you wish to get in touch. And I think it's back to Mark now to add some further insights on contractual arrangements.
Yeah, many thanks, Nick. Some really kind of interesting practical tips there. So thank you for that. Back into the world of contracts then. So when we're looking at contracts with clients, there's some further points which should be thought about here. I touched on some of these previously, but just to step through them now. So particularly if you're exporting goods overseas, then risk is going to be a relevant matter in terms of who bears responsibility for the goods at any moment in time, such that if they get damaged or lost, then who ultimately picks up the tab for that. We talked about Incoterms previously, and Nick mentioned them in his presentation as well. So Incoterms do deal with risk. So if you're thinking about using the Incoterms, then have a look at that and just check that you're comfortable with risk passing in the way that they would describe. Typically, as we mentioned before, Ex Works is the most favourable to the seller because it puts the least obligations on them and makes risk pass at the earliest point in that journey. But if you want to contrast that with one which is most favourable to the buyer, then you'd be looking at something like delivered duty paid, where basically the seller has to do everything except arrange for the unloading of the goods. So you can see on the diagrams on the internet that I mentioned how those things move along that spectrum, and it's just important to ensure you pick the one that you're comfortable with commercially and reflects the arrangements you've agreed. The reason that's important is because it obviously goes to business risk, but it might be relevant for some of the insurance things that you put in place as well. There may be some requirements around that, so you've got to match everything up there. Title, the second point listed on that slide there, I mentioned that that's not covered by Incoterms, and it's a really key point that needs to be covered in the contracts because this is about ownership. So even though you may have shipped the goods, at what point does ownership pass to the purchaser of them? And if that's to a new subsidiary that you've set up for the purposes of operating in that jurisdiction, then this is perhaps less of a concern as opposed to when you're selling the goods to a completely independent third party, for example, a new distributor you've just started working with. And the approaches here can be kind of similar to some of the things that Nick mentioned in his slide, in the sense of we can have what we call retention of title provisions, such that ownership doesn't pass until you've been paid for the relevant goods. And we can have other mechanics in terms of flow of funds to try and reduce the risk of not getting paid, or indeed the risk to you if title has passed but you've not been paid. So I mentioned some of the the guarantees, the bank bonds, the insurance policies previously, so they're all relevant and linked into this as well. So it's one part of a much bigger jigsaw, but title is obviously fundamental because you as a seller will want that title to pass as late in the process as you can. The challenge will be if you're selling to a distributor, then they're going to need that good title in order to be able to sell those goods on. So often there's a compromise where there's a middle ground where it's such that title passes on the later, let's say, of payment being received, or indeed the onward sale by the distributor. So it really depends how the arrangement is structured, but it needs some careful thought to make sure you're holding on to title as a seller as long as you can, or conversely, if you're a buyer, you're getting title when you need it to make that onward sale, if that's what's happening. Customs clearance and duties is something which is part of Incoterms, and it links into what Nick said about freight forwarding companies and customs clearance businesses, and that's really the mechanical piece of getting those goods through customs. And really, as lawyers, what we're doing is reflecting what the parties have agreed there in the commercial arrangements, because it's quite technical and needs the input of those specialists in those areas. Compliance with laws might sound quite obvious, but depending on the nature of the arrangement and the parties involved, you can see as a seller and a new entrant into a market that a distributor, particularly if they're quite large, might try to put some onus onto you in relation to compliance of laws with the local jurisdiction and governing law. That on the face of it might not seem like a problem, but if you've only previously sold your goods, let's say in the UK, then the chances are you haven't done due diligence in terms of whether those goods will comply in those other jurisdictions. So it's really quite fundamental that you do that to make sure that they're being sold lawfully and meet any requisite standards. And depending on what those goods are, will be depending on the things you check, but there could be things around product safety. And for example, in some US states, they might require additional warnings or markings to be placed on the goods or in the accompanying literature, for example. So there are a couple of examples of things on a very basic level that need to be thought about, but it comes back to that due diligence point. If you're planning to sell your goods into a new market, then it's very prudent to engage with your advisors to get that due diligence done at the outset, such that you don't have claims and complaints coming down the line later. Export licenses is something which John is going to talk about, or export controls, sorry, but export licenses fit into that. So some goods which are subject to export controls will need export licenses. We'll hear a bit more from John on that later, but clauses about export licenses can feature in commercial contracts, and they often do, around this kind of cluster of clauses which I've mentioned at the end there, to do with sanctions and export control clauses and resale restriction provisions. So this is a bunch of clauses that kind of all work together, such that if you're selling your goods on to a third party who's going to resell them, for example, a distributor, or indeed straight to an end customer, then you're going to want to make sure that those goods are not resold, if that's what's going to happen, or indeed used in breach of sanction and export control requirements. And some of the ways that might be done is by having general clauses in the contract around that. But if there's specific concerns, there might also be resale restriction provisions preventing the purchaser from using those goods for certain things, or indeed reselling them to other jurisdictions. The export licenses point could be relevant to the buyer or the seller, depending on who takes that responsibility and who's deemed to be making that export. So again, it needs that diligence. It needs to be applied to the facts of the particular arrangement that's in place. It is an ever-increasing area of scrutiny in relation to commercial contracts, in terms of the controls that are around goods and where they're going to, how they're going to be applied. So it's something that advisors will be looking at more closely, in terms of making sure that, so far as you can, you've got the right due diligence and controls in place in your supply chain, including in relation to onward sales, to make sure that sanctions regimes are respected. So without further ado, I think I'll hand over to John, who will give us a bit more information about export controls and sanctions compliance.
Thanks, Mark, and good morning, everybody. So by way of introduction, I actually have a technical background. I worked in commercial sales internationally for over 15 years, and then I transitioned, as happened to many practitioners these days. I was in a company who fell over export controls, let's say, knew nothing about it, and were called into question as to why they hadn't been operating with permits and licenses and so on. And so it fell to me to get involved and work out what was what, and the rest, as I say, is history. So export controls and sanctions compliance has been what I've focused on now for over 15 years. So export controls and sanctions have become much more centre stage over the last 10 or more years. I think it'd be difficult for people to have missed that entirely, whatever type of business you're involved in, whatever you do. But I wanted to start by just drawing the distinction between the two a little bit. They are much more intertwined these days than they used to be. Essentially, export controls have always referred to items that people export. So it can be goods, it can be materials, software, it can even be data and information. That gets referred to as technology in the export controls speak. Whereas sanctions, and there are a range of sanctions as well, they come in different forms. They are much more to do with either who you're dealing with or where you want to do business, where you are shipping things to. So that's essentially the way to think about them. One is sort of what's leaving these shores, and the other is who or where it's going to. We often summarize what's important in export controls and sanctions with a way to remember it is the 4 W's. So what is it that you are exporting? And whatever it might be that I've just referred to. Where is it going to? So that's the destination. Who is the recipient party? So now we're on to the people. And that means, you know, a legal entity, a business, whatever form it takes, who is receiving the goods or the information that is being shared or sold. And then finally, what is the purpose for the supply? You often hear people talk about end use, and that is what that's referring to. So that is addressing things like weapons of mass destruction, chemical, biological warfare objectives. So that's really the hard end of what export controls are about. Export controls very much had their origins in the military world. You know, I always say to people, putting it in the simplest of terms, you don't supply weapons to your enemies. But export controls has obviously matured and developed an awful long way from there in terms of military related equipment, sometimes things that you would think are incredibly benign and not of any danger or whatever, but there are controls on them. And that then in turn extends into the broader industrial and commercial world in terms of items that are actually made for commercial civilian application, but they've been deemed of potential use in perhaps a military context. So a good example there might be, for example, semiconductors all around us, made in their millions and shipped around the world. Obviously, you can do an awful lot with them, and there are some which are developed and can be used for military applications. There are those which they might not be made for military applications, but they could be really useful in terms of guiding missiles or providing navigation aids and so on. Let's move to the next slide, please, Mark. So Mark mentioned licenses. And yes, that's what this leads to in terms of when you've identified goods that have controls around them. The question then is, well, if they're controlled, are you able to export it to a particular country? In the UK, we benefit from having a very wide range of export license types, from general licenses through to very specific individual licenses for particular purposes that you have to apply for. But what's also important to know is, on the one hand, you could have a license for exporting out of the UK, but it's also necessary for controlled goods. If you arrange a contract from the UK for goods to be shipped from a third country to another third country, that can also need a license. That's what's commonly referred to as brokering. So you apply for, in UK parlance, it's a trade control license between two other countries. And again, it covers the full range of items that I've referred to previously, whatever form they take, materials, software, even technical information, all of that can be subject to licensing. But I think an important thing to remember, export controls and sanctions, certainly when you work in that area in lots of companies, they can often be seen, like other aspects of compliance perhaps, as the people who are stopping you doing business. And I think it's important to always regard the point about export compliance and sanctions compliance is understanding the rules, working out what can be done, particularly by virtue of getting an export or sanctions license. And then the compliance team actually becomes an enabling function in a business, not a function which is stopping business. Next slide. So I wanted to just highlight what are the factors that sort of determine the rules around export controls and sanctions compliance. There are a lot of them. This is just a very high level identification of the important ones. So in export controls, we have the Export Control Act of 2002, which is sort of that's a slightly more static piece of legislation, but it sets the foundations for export controls in this country. And then the Export Control Order of 2008 incorporates the details of how that is implemented. And in particular, that is where changes to the fundamental details are recorded and enacted. One of the key pieces of legislation, or what the Export Control Order encompasses, should I say, is what's referred to as the UK's Strategic Export Control List. And that in turn encompasses a lot of different bits of regulations, which actually define specifically items that have controls around them. And a key part of that is some retained legislation from the EU that we retained with Brexit, this Regulation 428/2009. So that is what contains the detailed listing of items that have restrictions around them. The EU, in the meantime, updated that piece of regulation. So in 2021, there is a new version of that, a thoroughly overhauled version of that legislation for the EU. But thankfully, they still have an awful lot in common. So for people who deal with EU countries and might ever be involved in exporting from those as well, the control status of anything is pretty much the same. Moving to sanctions. So a key piece of legislation there, again, which is kind of, since Brexit, has become the foundation for all UK initiatives on sanctions, is the Sanctions and Anti-Money Laundering Act of 2018. From that, there have been a number of, well, there are regularly updates and statutory instruments that get issued on the basis of the law that is founded in that act. And also going back a bit further, there is some relevance of the Counter-Terrorism Act of 2008, Anti-Terrorism Crime and Security Act from 2001. This is going back to when, fundamentally related to terrorism, there were measures introduced to introduce protections and means by which people who were obviously acting against the interests of the country from a security standpoint could be brought to justice, and that also has implications with the sanctions which could be placed against entities or individuals identified in that context. Let's move on. So I thought it might be interesting just to kind of illustrate what goes on and what this is about with a couple of cases that have come to light recently. And interestingly, just yesterday, the government published quite a comprehensive new policy paper on sanctions enforcement. And one of the first things it states in there is that, you know, and it's actually a cross-party initiative, that sanctions measures are only effective if they are properly enforced. It's something that in my area we've been saying for years. If you have visibility internationally on these matters, the US has led the field by a long way for many, many years in terms of the how hard it comes down on people who breach the rules. And there are very, very large fines issued, and they have been quite regularly applied. Whereas until recently, the UK had really not done very much in this area. Fines had been very small, very notional, and it leads one to ask the question, you know, what's the point almost? So it's only really by showing what the consequences are of a breach and not paying attention to the rules that I think you wake people up to pay attention. And that's the trend we're seeing. You know, fines in the UK are now regularly in six figures, and there have been fines and penalties in millions as well. So just an example here, 2024 in November, there was a company, a well-established supplier actually in the north of England, but they, for whatever reason, they had decided to not bother with obtaining export licenses to supply some flight simulators, which seems very difficult to understand, but you know, they had their motives. They thought they could get away with it. They were picked up, and so they were fined 90,000 for evading those license requirements. I mean, those flight simulators were only worth 38,000, so you know, that really wasn't good business. And licenses, by the way, don't cost anything. They only cost the effort of applying to the government for an export permit. And had they done so, there's every reason to think they would have got one in this instance, because this was a supply to the UAE, actually. And then more recently, November 25, Bank of Scotland was fined 160,000 because they hadn't done sufficient due diligence on someone who turned out to be a so-called designated person. They had actually done some screening, but their tool was not up to scratch and didn't pick up the fact that the person's name perhaps had different spellings, and so they didn't realize it was a designated person when actually it was. And the third example is just last month. And this is just to illustrate that it's not just fines. You know, you can go to jail if you are responsible for your company's actions as a director. And a company director was jailed for 2 years, I think it was, for exporting thermal imaging rifle sights and you know, trying to get away with describing them just as cameras. But they are controlled. A key part of the UK strategic export control list I mentioned is the military section, and these are specifically designated in that list and hence subject to controls. So as with most things, all of this is covered by a variety of different government departments. And again, I'm just highlighting the principal ones here. I think it's important to know where you go to, who you contact if you need support. The primary entity for export controls for a long time has been the Export Control Joint Unit. And what they do is they are the organization that first and foremost handles all license applications. But above that, they also actually provide an awful lot of support to business. They are there to help businesses. Being part of the DBT, you know, they want businesses to have successful exports. And so they do a lot of outreach. They are there to consult with if you have questions about what's what. To the extent that they've got enough resources to do it, they should be able to get back and help people. But the other thing that they will do is they come out and audit businesses if they have started to use certain licenses. So there are licenses that you can simply register to use. So you don't have to share any information about your business, really. You just put the very basic, who you are, where you're based, and you register, and you can actually use what's called a general license. So obviously, if the government's allowing people to do that, at some point they need to check that actually they are operating in a manner which is responsible, and they are in compliance with the terms and conditions. So using a general license will trigger at some point in the following time period, anything between 6 months and 2 years in practice, an audit from those people. But again, the audit is not one which will directly lead to any penalties or anything like that if you're not up to scratch, and they will seek to help you put things right if you're not ticking all the boxes. But they are an important organization when it comes to export controls. Within the DBT more recently, we have the Office of Trade Sanctions Implementation, which was only came into being about 2 years ago. And their remit is very much focused, as the name implies, on the trade sanctions, which are distinct from financial sanctions and some of the other sanctions which are around. So OTC was modeled very much on OFC, which I'll come to in a second, but aligned to the DBT by nature of what they do. Then within the Department of the Treasury, we have OFC, I just mentioned that they have been around for quite some time, implementing and administering the financial sanctions, which have been in existence for a long time, handling lists of designated parties and so on, and following up, investigating cases where there have been issues and so on. But also under the Treasury, then we have HMRC, and who obviously we've heard about already. HMRC has a very broad remit, does a lot of different things. But in this context, HMRC, in the context of export controls and sanctions compliance, effectively is the policing agency. So if there is a breach, whether it's been found out by the authorities or whether you volunteer it as a company, and that is always highly recommendable if you discover you have breached, you had a misunderstanding, or there was a simple oversight, then it's best to put your hand up, so to speak. You get an awful lot more credit in terms of their decision if you do that. But HMRC is ultimately where the policing occurs of anything going wrong. Next. So that was a very quick run through on some of the key facts and how things work with export controls and sanctions. And I just wanted to finish with, these are my tips and advice, which if you want to understand any more about what they entail, then feel free to come and ask. But the important thing is to start with the risk assessment, to understand whether you are going to be compliant or what you need to do to be compliant. Obviously, you need to understand, well, what risks do we have? Are we in a risky business? If you're trying to sell weapons to the Middle East, the answer is most likely yes. If you're selling children's toys to the EU, with a few exceptions, you probably haven't quite got the same level of risks. But important, understand your business activities, and geography comes into play clearly from what I've been saying about sanctions. Geography is really important. Who are you trading with? Where are you trading, etc. And the second thing here, knowing your products and their export classification. So on the export controls side, we always say, export controls starts with classification. So if there is any suggestion from number one that your products might fall into categories that would attract controls, then you need to classify. You need to review them all review product groups, and then maybe review actually getting down to individual parts to classify what they are. So if you're exporting, if you have export control implications. If you then know that they're controlled, you have to understand the licensing options and obtain licenses in good time. Registration for a general license is instantaneous, but if you have to submit a license application, it can take a number of weeks before you get it through. So you don't want to ask for that the day before you're due to ship. It is important to understand about it in advance. In terms of the sanctions, you should be screening who you do business with and associated parties to a transaction, not just necessarily the direct customer or agent, but you need to understand that what I call the downstream supply chain. Who are you supplying to? Who are they supplying to? Who are they sharing it with, etc., etc. You need to be on top of any applicable sanctions or embargoes that affect the countries you're trading with. And sometimes that can also, when it comes to shipping, you're also interested in shipping routes, especially if you're responsible for shipping, where it's going through. So we always used to use Iran as an example. I mean, at the moment, unfortunately, it's a very obvious example of something you wouldn't do. But there was a time when, say, for example, people shipping to Pakistan would ship through Iran. Well, that actually wasn't allowed. So it was understanding what you can or can't ship by what route. So then we have circumvention. So the recent Russian sanctions have really highlighted the issues of circumvention. There's all kinds of sanctions against Russia, so there's very little that you really can legitimately send to Russia. But a lot of companies who have stopped their business in Russia, so they find that they have an awful lot of business through Turkey or Kazakhstan or wherever it might be. And surprise, surprise, a lot of those goods are ending up in Russia. And the last thing is with everything, these rules are changing frequently, especially on the sanction side since 2022. So it's really important that you do have a mechanism for staying on top of what might change. Whether that means that you sign up to email updates from a particular body, a government agency, or you have somebody in the business who just is tasked with, reviewing what's changing, or you engage an outside party. Whatever it is, it's important to stay on top of the rules. Okay, so that was my quick run through. They're my contact details, and I'll hand you back to Mark.
Thanks very much, John. Some really interesting points there, particularly in relation to things you touched on in relation to downstream supply chain and some of the due diligence that was mentioned previously. Some of the clauses in the contracts are one piece of a toolkit to mitigate, for businesses to mitigate that risk. Clearly, they're not the be all and end all of it, but they're an important part of demonstrating that you're trying to be compliant with the rules. So just to kind of build on as the final slide, really, in terms of some of the things that John has said there. Due diligence is an important thing from a legal and a compliance perspective, really. Some of these things John's already mentioned, so I won't dwell on them really, but understanding who your customer is before you kind of get into that supply relationship, both in terms of the direct customer and, as John mentioned, further down the supply chain in terms of the downstream supply. But one of the key things from a legal perspective and a regulatory perspective is documenting what you've done in terms of the diligence. So you've got to make sure, and it's a bit similar in terms of what Nick was describing about the bundle of documents, the evidence pack. You want to make sure that you've got a robust evidence pack here to show what you've done, such that if questions are ever asked in terms of your compliance arrangements, you can demonstrate what you've done and demonstrate that you've been prudent in terms of the checks you've done. But really, to highlight, that's not a one-off exercise. That's got to be done on an ongoing monitoring basis. John mentioned about changes to rules, etc. But people can move on and off of sanctions lists, etc. So it is important that you're able to monitor that on an ongoing basis. And that can be done in a very manual way, but there are also automated tools which can help with that. the ongoing monitoring is not also relevant just to people. It's also relevant to some of the licenses that you might be operating under. So, for example, under sanctions regime, sometimes the licenses are granted for very specific tasks or activities, and indeed up to specific financial limits. So you need to keep those under review to ensure that you're operating within those licenses, and if something needs to change, then you need to make that application before you exceed the financial limit or before you undertake that other task, or else you might not be covered there. John very clearly described around classification of goods, so there's nothing else I can really add on that other than say it can be quite technical. Some of the descriptions are quite technical, so the advice of somebody like John in that is really invaluable, because you really need that specialist input into how things are going to be classified, because it can then mean that it can provide opportunities for the business in terms of being able to supply, rather than just flatly turning down potential orders because those classifications are not understood. So it can add real value there. Indeed, it can also help ensure compliance, because if something does fall into a category that needs a license or a permit, then that can be obtained to ensure the lawful supply. Two general points really to finish on. They're not specific to this topic, but in any kind of arrangement where there's going to be suppliers of goods, both in the UK and overseas, then the Bribery Act is a relevant consideration. It's been around a long time now, but if you're moving into a new jurisdiction, you want to make sure that the arrangements around that are compliant. So if you have existing policies and procedures that are in place, you might need to look at them and update them. You might also want to do some diligence in terms of the supply chain there to make sure that everything's compliant. Same point really in relation to modern slavery, in terms of checking supply chains, etc. But like I say, they're not specific to exports. They're general points, but they're definitely worth thinking about in relation to that. So I think that really brings us to the end of the points that we wanted to run through, and I hope that everybody's found that useful. As we mentioned at the start, we are going to make available a copy of this webinar and also a copy of the slides after the event, so you can refer back to them if you need to. Listed on the slides there are our contact details. If you've got any questions that you would like to ask us after the event, then please feel free to do so. We do have a couple of minutes for questions in case any have come through. Olivia, I don't know if there's anything that's come through now.
Not just yet.
Not just yet. We'll give a couple of minutes then, just in case anybody does have any questions they would like to ask. Otherwise, if nothing comes through fairly soon, then we'll wrap the session up, and we'll be sure to share a copy of the webinar afterwards. Okay, so we'll just give a few more seconds just in case anybody's typing something at the moment, Olivia, and then otherwise I think just to say thanks everybody for joining, and look out for the slides and a copy of the webinar, and if you've got any questions, please get in touch. Fantastic. Anything there, Olivia?
No, nothing.
Okay, all right. Well, thanks everybody for joining. I hope you found it useful, and keep in touch.
Thank you.
Thank you.
Bye-bye.
Yeah. Thanks everyone. Bye.
Bye.